County State Court. If you know your party's extension, you may enter it now. For court hours, State Court.
Hi there. I'm calling to do a motion hearing telephonically this morning.
Okay. Can I ask your name?
Yeah, my name's James Goodbaudy.
It looks like you're going to be in courtroom 100.
Yeah, with Matthias.
Perfect. If you let me put you on hold, I'll get you down to the courtroom, okay?
Thank you.
Thank you. Courtroom 100. Is this Mr. Goodbaudy?
Yes, it is.
Great. I'll transfer you in the courtroom, sir.
Okay.
Mr. Goodbaudy, can you hear me, sir?
Yes, I can.
Okay, great. The judge is not with us yet. Mr. McCracken from the District Attorney's office is here representing the state.
Okay, thank you.
All rise. Go ahead and be seated. Good morning. Do we have Mr. Goodbaudy on the phone?
Yes, you do.
All right, good morning. We have
Morning.
Mr. McCracken here in the courtroom, and this is the time to address, I believe, the motion to strike or dismiss complaint and request for full finding of fact and conclusions of law filed by Mr. Goodbaudy. And just for clarification, we have two outstanding case files, 127136 and 126176. Mr. Goodbaudy, are you intending that this motion address the issues that you've raised for both cases, or just the failure to display the license case?
I believe it's applicable to both cases.
All right. State prepared to regarding that?
Your Honor, yes.
Go ahead and remain seated if you prefer, because I want to make sure Mr. Goodbaudy can hear you on the phone.
The state is certainly prepared to proceed. I don't, frankly, know exactly what's being asked for in these motions. I don't know if you've had a chance to review them, but these are not things that I've ever seen, issues I've ever seen raised, ever. Number one. Number two, I don't know that there's any, well, most of the authority cited is not applicable to Oregon, number one. And many of the issues raised just simply don't have anything to do with dismissing a complaint. So yes, we are ready to proceed insofar as the cause of action has been raised by this motion.
Okay, so we'll address this as best we can, but just to clarify, Mr. Goodbaudy, in the caption of your motion, you have case 12-7136, which deals with the failure to display license. Then there's a slash, and then there's another number that I have not been able to identify. Can you tell me what that refers to, please?
It's just another case number with some correspondence I received from the court. I'm not exact. What's that?
I'm just wondering if that could be the DA number or the police number. Mr. McCracken, do you know what that number might refer to?
I'm sorry, which number you're on?
It's 12785. Just want to make sure I'm not missing something here.
I believe that is the DA number.
DA number? Okay, so that would be incorporated into 12-7136, I guess. And then the other case number, of course, is 12-6176, which addresses the obtaining contents of communication charge. And there's a slash, and then there's another number, 12-52263F, which is a traffic violation that has previously been resolved. So, all
Okay.
right.
Makes sense. Thank you for clarifying that.
Okay, you're welcome. So let's proceed then. Mr. Goodbaudy, these are your motions, your allegations, so I would like to start with you presenting your summary and argument. Then I may have some questions for you. Then I'll give Mr. McCracken from the DA's office a chance to respond to your motion, and then give you a chance to follow up, Mr. Goodbaudy, any other comment or argument that you'd like to present. Now, you've asked for full finding of fact and conclusions of law. Can you tell me what you are expecting when you make that request, please?
Well, really, I would like to see some facts and evidence on the applicability of the law and how it is applicable to me at the time of the arrest.
So you're asking for a written ruling? Is that what you're asking for, or an oral ruling?
Either way, I just like to understand what facts are in evidence as far as this is concerned.
And so are there any other matters to present or discuss before we begin, gentlemen?
I believe so, Your Honor.
All right, Mr. Goodbaudy, go ahead and say what you'd like to say regarding your motion to strike or dismiss the complaint.
Okay, well, I would state that the sole purpose of government is to secure and protect rights. So,
Where do you, let me just ask you real quick, where do you derive that authority? What is your basis for that statement?
the Constitution of the United States.
Okay, thank you.
Yes. And I believe a fundamental aspect of getting having jurisdiction is showing that the law is actually, or the statute, code, whatever, is actually applicable to the defendant at the time of the arrest. Also, there is no real adversary. There's no facts and evidence that there is an actual adversary, that there is a victim, or corpus delicti. There's no case, crime, cause of action. The foundation for the court's jurisdiction is the purpose of American government itself. This is the Declaration of Independence, 1766. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. This is why, to have a case or cause of action, a plaintiff must plead the violation of a legal right.
Your Honor, I've read the motion. If it's just going to read the motion into the record, I don't think that's really necessary.
Are you intending to read your motion into the record?
Just parts of it.
Okay.
Like, I'm not going to go over the case law, and, that's not necessary. But the basic elements of a case or cause of action is the violation of a legal right and loss or harm. The alleged plaintiff, a legal fiction at best, acting through chance more, has not pled any violation of a legal right or harm. Legally, there is no cause of action. So even if the absurd claim is made, harm is not a necessary element of a real crime, the complaint is still fatally flawed, as there is no accusation alleged defendant violated anyone's legal rights. So there is not in any real sense any adversary. If there were a true adversary against alleged defendant, it would be laughable to even try to discuss causation, because defendant is not accused of causing anything real or imagined. There is no adversary. Alleged plaintiff, a fiction at best, acting through chance more, who has not alleged the violation of a legal right. The complaint is unfit for adjudication. Also, there is no corpus delicti, which means the body of crime itself. Virtually every American jurisdiction agrees it's an absolutely essential element of any crime and is consistent with the stated purpose of American governments and the basics of adversary proceedings. This is not the same as the corpus delicti rule, which is not an element of the alleged crime, but a procedural rule. So there is no corpus delicti pled in the complaint. Without a corpus delicti, there is no crime. Again, this is based on the purpose of American governments being limited to only protecting rights. And that's why an injury is always required. Also, there is lack of jurisdiction.
Can I ask you one question about that?
Sure.
What about the government's authority to delegate what about the government's authority to establish courts to enforce, laws of the state? What is your argument there?
Well, I would like to define factually what the state actually is. Is it the ground? Because
you're arguing that it doesn't exist. Am I understanding your argument?
Well, it's an obligation. The contractual or the agreement between the citizen and the state is one of the state has the duty to protect the citizen, and the citizen has the duty of allegiance to the state. However, there are several Supreme Court rulings that have determined that the state has no duty to protect. So there is no agreement anymore.
Can you tell me what those cases are?
I don't
Are they
have.
cited in your paperwork?
I believe so, yes, but I'm not sure
Do you know which
exactly.
ones offhand? Because I haven't had a chance to read all the cases you cited. Do you know which ones make that claim?
I don't have that here right now. I mean, if you could give me a minute, I could probably find it.
Okay, go ahead.
How about Warren versus District of Columbia?
Which page of your memo are you referring?
It's not in my.
Okay.
Yeah.
Tell me the site then.
It is Warren versus District of Columbia. It's District of Columbia Court of Appeals equivalent to a state Supreme Court case held. Police
Hold on a second. Go ahead.
do not have a duty to provide police services to individuals, even if a dispatcher promises help to be on the way, except when police develop a special duty to particular individuals. So that right there negates the duty to protect. And that's one of several. I just don't have the other ones right offhand, but I can get them.
Let me get that citation though, so I could look it up myself. You said District
Warren versus District of Columbia, 444 A 2D 1, D.C. Court of Appeals, 1981.
What year is that? Do you have that?
1981.
Thank you very much. Okay, go ahead.
Yeah, I believe that covers it. I mean, I would like to just see some facts entered into evidence that there is that the applicability of the law was in place at the time of the arrest. I'd like to see, how the alleged plaintiff was injured or harmed, how he may have suffered a loss. Otherwise, there's no real adversary, and this is an adversarial proceeding. Without an adversary, there is no proceeding. I think that's about it. If you'd like to discuss anything in the motion, that's fine with me.
One question I did have for you, some of your allegations refer to the lack of evidence or the lack of facts. Now, would that not be the burden of the state to present at trial rather than making a factual determination today?
Well, the purpose of this hearing today is to try and figure out if we even have to go to trial. If there's there's no real adversary, and if the law is not applicable, then there's no reason to go to trial, I would think.
No, I understand that, but assuming, for argument's sake, if I deny your motion, do you not still have the right and ability to challenge the facts or the lack thereof in front of a jury?
Well, these issues are not going to go away in front of a jury. I believe I can convince them at trial to do an acquittal or at least a hung jury. So, because I don't believe that any facts will be entered into evidence that will prove beyond a reasonable doubt, with facts, not opinions, that you have met your burden of proof.
All right. Not my burden of proof. It would be the state.
I'm sorry. Yes, the prosecutors.
Okay, good. Okay.
Yeah.
And so, let me just see.
I would just like to see how. I would like to know if the cause of action is actually even valid to begin with, and what the elements of a valid cause of action are, and just to show that the law is applicable, and to show that there is a real adversary. That would.
Another question I had for you. In the first allegation where you say no case, crime, or cause of action, one of your authorities states when you say the foundation for the court's jurisdiction is for the purpose of American government itself, drawing on the Declaration of Independence. You go on to say that is why to have a case or cause of action plaintiff must plead the violation of a legal right. So one of your citations reflects that in the absence of a statute, a party has standing to assert only its own legal rights. In this instance, at least as far as I can tell, you're being charged with violating state statute in two different ways. Two different instances, I guess. What is your position regarding the state's ability to create legislation to make legal or illegal certain things? What do you say about that?
I say that the Constitution is not applicable to me. Statute is not applicable to me without consent. There has to be mutual consent. Is this a tort or a contract dispute?
What if it's neither? What if it's a criminal case?
Then there needs to be injury or loss, I would imagine.
And let me see if I have any other questions. You said in under allegations for lack of jurisdiction, although that's kind of a common theme in your writing here, when you say because American governments are established for the sole purpose of protecting life, Tell me again where you derived that.
It is in the Declaration of Independence, 1776.
Okay, can you tell me which provision you're referring to of that document?
You mean like what, paragraph or something?
Yeah, yes, just so I can understand fully your argument. And if you can't locate it at the moment, that's fine too.
Oh, yes, I'm not exactly sure what paragraph it is. I know that it is contained within that document, though, and that the context in which it is used is certainly applicable to this case.
Okay. And then I had another question for you. On the last page, or actually the last page of the actual motion, on the conclusion page, I should say, at the very top, where you say, mere geographic location is not evidence of presence within the alleged plaintiff, state of Oregon. My question to you is, what would be evidence of presence within the alleged plaintiff, state of Oregon? What circumstances do you see that would be considered adequate evidence?
You're asking me for evidence when you...
No, I'm just asking you, just in theory, what... And if you can't answer or don't prefer to answer, that's fine, but I was just curious when you say mere geographic location, it sort of infers any other things that may suggest presence, and so I wanted to ask you about that, if you could.
Yes, perhaps it would be helpful if the state could also enter evidence into the record that shows that I was actually within the state of Oregon at the time of the arrest. And to help clarify that, think of maybe the Catholic Church, how they have certain geographic areas where their diocese is located, and they, if you're located within that area, you're not automatically Catholic if you're within their area. So I think that the state really needs to prove that I am subject to the statute and code. I think that's a vital element and a very important aspect of this case, and I feel like it's not something that should be going to trial without that.
Okay, thank you. Then dropping down to the middle of the page there, where the paragraph where you started, this is a criminal proceeding, and the assigned judge is obligated to presume my innocence until it is proven beyond a reasonable doubt. The judge may not assume a law is applicable now because it is an essential element of the alleged crime. I'm not quite sure I understand what you mean. Can you explain what you mean by that?
Yes. Well, can you answer a couple questions for me real quick?
If I can.
Am I presumed innocent of these alleged crimes?
All charged defendants are presumed innocent.
So am I presumed innocent of every element of these crimes?
Yes.
Isn't a very fundamental element jurisdiction? So if I'm considered innocent, then you are considered to not have jurisdiction.
And that's what I wanted you to explain a little bit.
Yes.
I didn't understand that statement. So tell me again what you mean by this.
What I mean by this is, if you are obliged to presume my innocence, you are obliged to presume my innocence of every element of the crime, every element of the crime, and a very basic element of that is jurisdiction. So if I'm presumed innocent of every element of the crime, you are presumed to not have jurisdiction.
Okay, I understand. All right. Is there anything more that you'd like to say about this motion before I ask Mr. McCracken to respond?
I think I covered it pretty well. I would, yeah.
And Mr. McCracken, how would you like to respond?
Your Honor, a couple of things. Number one, the state would make a motion at this time to strike this motion because I don't think that it has anything to do with any real legal arguments that are applicable to a criminal case. Number two, motion of the defendant, the state would still have to prove all of the elements of the charged conduct beyond a reasonable doubt at trial, which we obviously intend to do. Just a few statutes that I think are at least somewhat applicable to some of the things that the defendant has mentioned today.
But how is the statute applicable to me is what I would
Hold
like.
on a second. I'll give you a chance to respond.
Okay, I'm sorry. Go ahead.
To be able to make his argument. Go ahead.
There were a number of statements about it's not an adversarial action unless there's a victim involved. There's nothing in the Oregon Constitution or statute that I've ever seen that makes that true. Initially, the one thing I'm not going to argue the basis of government or the reason that government exists, because it has nothing to do with when a criminal complaint or a citation has been filed. Further, the Declaration of Independence has, from my understanding of having gone to law school, no precedential value in a criminal case. The Constitution certainly does, but not the preamble or the Declaration of Independence. ORS 131.025 states who the parties in the criminal action are. And it says, except for offenses based on municipal or county ordinances, neither of which these are, in a criminal action, the state of Oregon is the plaintiff, and the person prosecuted is the defendant. So that's where the parties come from, and that's by statute. Concerning jurisdiction, while we do have to prove that as an element of the crime, the jurisdictional definition in the Oregon statute is that this state, quote, in 131.205, this state means the land and water, the airspace above the land and water, with respect to which the state of Oregon has legislative jurisdiction. So the citation and the complaint both indicate that these acts occurred in Clatsop County. Citations even more specific that it was on Sunset Beach. Both of those are in the legislative jurisdiction of the state of Oregon. Again, the state would have to prove at trial that the defendant was in the county in class in order for him to be convicted of these crimes, and the state intends to do that. The jurisdictional statute in 131.215, directly below the statute indicating what this state is, under subsection 1, it indicates that the state, that a person is subject to prosecution under the laws of this state for an offense which the person commits, the conduct of the person or the conduct of another for which the person is criminally liable. And under subsection 1, it says if it's either the conduct that is an element of the offense or the result that is an element occurs within this state. So that's how the state has jurisdiction by statute. Concerning, while this isn't really mentioned in the motion, I think that probably this is the heart of what he intended to attack, the citation and or the complaint, and whether or not they state a cause of action. I think that statutorily both do. Under 133.055, it talks about the criminal citation, and a peace officer may issue a criminal citation to a person if the peace officer has probable cause to believe that the person has committed a misdemeanor. In this case, Deputy Chance Moore did have probable cause to believe that the defendant committed a misdemeanor and cited him. He did a citation issued with a complaint, which is defined and set out the requirements for in ORS 133.069. Again, that citation does include the name of the court at which the defendant was cited to appear, his name, the defendant's name. It also indicates the state or other public body in whose name the action is brought, in this case the state of Oregon, and the name of the defendant, getting back to the party statute from earlier. That there's a statement or designation of the crime that can be readily understood by a person making a reasonable effort to do so, the date, time, and place at which the crime is alleged to be committed. In the first case, it's the failed to carry and present the license, and it also lists the statute number. In the second case, the complaint, which indicates what the cause of action is, the lawful communication, where it happened, and what the acts were that are the elements of the crime. The one issue that's come up in the past in cases like this where someone represents themselves when they say, well, I don't know what that statute means, it's not fair to me because I'm not a lawyer. citation, unless it's an extremely complicated case, neither of which these are. And the defendant has been informed of his rights to criminal discovery. I don't know if he's picked it up. I know that a few weeks ago it was prepared for him. So I don't think that that's a viable argument that the complaint or the citation are not definite and certain enough, or that they don't provide him enough information to understand the charges against him. And 133.015 indicates what the contents of an information or complaint, what's required there. Again, it almost mirrors the citation issued with the complaint, where it entitled the action, the court, what the defendant is being accused of, etc. A statement of the acts constituting the offense in ordinary and concise language, without repetition, and in such manner as to enable a person of common understanding to know what is intended. Also has to be verified by the complainant. And in both of these cases, the statutory obligations are met, one for the complaint, but for the citation with the complaint, and the other one as a DA complaint. Again, the statutes define what the jurisdiction is, the statutes define what the state of Oregon is, the statutes define what starts a criminal action, and the statutes have been complied with in both of these cases. Anything else that the defendant is interested in finding out, he will find out at trial when the case is proved beyond a reasonable doubt by the state. The state is not obligated to provide all this evidence in the pretrial hearing to talk about whether or not a citation is valid.
All right. Thank you. Mr. Goodbaudy, you have an opportunity now to respond to the arguments presented by Mr. McCracken. What would you like to say?
Well, I would like to respond initially by, he first stated that he knew nowhere in the Constitution of the state of Oregon how statute was not applicable, I believe, or something like that. I'd like to read Article 1, Section 11, part of it anyway. Rights of accused in criminal prosecution. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand the nature and cause of the accusation against him. I'll stop right there because I don't believe that there's a valid cause of action in this case. And also, the prosecutor has failed to connect me to statute. He has failed to show that he has failed to enter any facts to the record that stated the statute or even the Constitution or any law is applicable to me. That's the main question. How is it applicable to me? Where did I make that agreement? And is he qualified to testify to my presence within the state and applicability of the laws anyway? Opinions are not satisfactory. And even case law are all decisions. I'm looking for facts.
Okay. And so, Mr. McCracken, anything else in response?
I have nothing further.
Okay.
I mean, I guess all I would say is that Mr. Goodbaudy does not feel that there is a proper cause of action and he can fail to show up and it won't be issued.
All right.
No, I intend on remaining honorable in every part of this whole thing.
Okay. So let me just say I'm going to take this motion under advisement and return to you in writing after considering the arguments you presented. And so I'm going to assume that, Mr. Goodbaudy, you want me to address those cases in this motion to strike or dismiss. So I'm going to do that. I note that the case 12...
And hey, can I add one more thing?
Sure.
I am willing to enter a plea of guilty if you guys can show facts how the law is applicable to me. No problem.
Okay. And so let me give you my ruling, and that may inform that decision of yours. Looks like we've got trial set already on case 12-7136. The date is November 14th, was docket call the week before, not December, November 14th trial, and November 8th for docket call. call at 11 o'clock, and that is on the failure to display license case, case 12-6176. I'll make sure that is also set for trial. Actually, that's set for trial on November 14th as well, with docket call November 8th. So the state's intention is to try both of these at the same time.
So the defendant's wish, Your Honor.
Oh, that was your wish, Mr.
Yes.
Goodbaudy. Is that still your wish today?
Yes.
All right, and so I'll get back to you in writing prior to docket call so that you can advise the court at the time of docket call if the case can be resolved or if you're going to proceed to trial. Okay?
Okay, thank you very much.
All right, you're very welcome, Mr. McCracken. Thank you very much, and we'll let you go.
Okay.
Bye.
Bye.